Welcome to SpringLaw's 2019 SpringFoward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit SpringLaw at www.springlaw.ca. And now to our presenters.
Good morning, everyone, and welcome to the SpringFoward Legal Updates, our monthly webinar series. Today is the 9th and final of our 2019 monthly webinars, and the topic is 2019 Wrap-Up, Top Tips for Your Top 3 Legal Issues in 2020. And we pick these legal issues based on the questions and issues we get from our clients, and based on how the law is evolving and what the courts are saying, and we choose things that hopefully will have an impact for you in your work lives. We have a large number of people attending our webinar today, so thanks for joining us. I'm joined by Hilary Page, and my name is Marnie Baizley. Hilary's a little under the weather today, but you won't know it. I've been chatting with her, and she's a trooper. She's here. If you're one of our clients, you already know that we're employment, labor, and contracts lawyers at our virtual law firm based in Ontario. And if you're new to our law firm community, welcome. You can ask questions through the chat function, and you can download the slides for the presentation under the Handouts tab. And finally, a little bit about our firm. You can check us out at springlaw.ca, and we have a variety of great resources there, including our award-winning weekly blog posts. They really are fantastic, and I can say that because I haven't written most of them, many of them. They have lots of practical information, and they're written in plain language, and they really are awesome. We get a lot of unsolicited positive feedback on our blog posts. There's also a link to subscribe to our monthly newsletter there, and information about our innovative subscription program for employers. We've had good feedback from our clients about this program. It's based on a flat fee concept for documents and materials that are typical in workplaces, and alongside of that is some strategic legal advice and real life lawyers helping to implement those documents. So that's a real valuable offering in our view. On the website, you'll also see a link to purchase our ebook for employees who are recently fired and looking for an alternative to personal legal services. So let's jump in. Our presentation today, as I said, is based on our top legal issues we've identified. The first is handling your gig employees. There's many workforces have lots of entrepreneurial folks who are doing their own things on the side. Hilary's going to talk to you about that and how to navigate those issues. Top legal issue number 2, investigating harassment complaints and incidences in your workplace. I'm going to speak to you about that today. And our top legal issue number 3, auditing your employment contracts. I mentioned that we follow the case law closely. Hilary does that really well, and she's really got her finger on the pulse of how the law is evolving, and employment contracts and what needs to be updated in employment contracts often evolves out of recent case law. So that's why that topic is here for you today.
Okay, so let's get started with top legal issue number 1, handling your gig employees. So something we see that comes up quite a bit with employers who do have these sort of people who are gigging on the side is moonlighting. So moonlighting is when an employee also has another job. So that's their moonlighting job. I like that term. So it's like a side hustle, but the legal term is moonlighting. And this is totally common, especially in sort of the millennial set and in tech workplaces. Often that's not going to be a problem, but sometimes it is. And so we want to set up the employment relationship so that the employee sort of understands the limits of what they can do moonlighting or side hustling, and make sure that it's not going to impact their full-time job. So we generally would do this through policies and contracts. So the full-time and attention clause is a great clause to have in a contract, which will say something like, you will devote your full time and attention to this job. There are also going to be things in there about not using employer resources for personal pursuits, and then of course avoiding conflicts of interest. And I think this is the biggest issue when we talk about moonlighting. If you are a web designer, you don't want your employee running their own side business as a web designer, right? Because you're sort of buying that skill of theirs, and if they were doing that, they could be competing with you. So really strong conflicts of interest policies, and making sure that employees understand the limits of what they can do as a side hustle is super important. Another common thing we're seeing, and there's definitely even a push towards this in the legislation, is employees expecting more flexibility in terms of their job and requesting remote work arrangements. So we do encourage employers to have an open mind when it comes to this, because often, or studies have shown that employees who work remotely actually often work more. They get more done than they would in the office. And I think they're often also happier because they have that control over their environment. They can have a snack when they want to. They get that focused time. Our webinar last month was all about remote work, and you can watch that on our YouTube channel, I believe. Lots of tips and tricks in there, but it is definitely something that we're seeing people wanting and asking for. So again, there are things you want to consider here. So having a remote working policy, usually that might be also something that is appended to an employment agreement. So something that the employee understands when they come in. And you're going to need to consider things like confidential information. So is the employee going to be taking home confidential documents? How are they going to ensure that those are protected the same way they would be in the office? Making sure that all their tech systems are set up with security that's appropriate. When employees aren't physically in the office, how are you going to ensure that they're connected? So you want to maintain that relationship. You want to make sure that, you know, they're still available during working hours. So putting something like that in there, and then not every job obviously is going to be suitable for remote work. So delineating that clearly in a policy, so which roles are going to be eligible. Federal employers, so these are employers like banks, airlines, anything to do with the global sort of interconnection of the country. The Canada Labour Code applies to these employers, and there's actually a provision in the Canada Labour Code, section, I wrote it down here, 177.1 of the Canada Labour Code addresses flexible work requests, and employers have to take these requests seriously. So an employee after 6 months can request flexible work arrangement. So that might be flexible hours, it might be working from home, and the employer can only deny that request for specific reasons, and those are set out in the Canada Labour Code, section 177.1. But that just sort of goes to show that this is definitely a trend we're seeing, and even, you know, the legislature is saying we need to take these requests seriously. And over to you, Marnie.
Thank you, Hilary. I'll jump in for top legal issue number 2, investigating harassment complaints in your workplace. Speaking of trends, unfortunately, this is a trend we're seeing because, as many of you will know, there's an obligation.
Very hot trend.
Yeah, it's a very hot trend. Obligation to investigate incidences and complaints of harassment in workplaces. So the top tip number 1 that we've laid out is understanding the duty to investigate. So when you have some discord in your workplace, is it a interpersonal conflict between a couple of employees that they can work out on their own that doesn't need a third person or third, fourth, fifth person to become involved to help them resolve it? Or is this something that is bordering on harassment and triggering that duty to investigate under the Occupational Health and Safety Act? So that's the threshold question, and we'll say that the duty to investigate is fairly easily triggered, and so erring on the side of caution is a good idea. And there are very specific OSHA requirements to follow. So it's not something that an employer or a person wearing a pseudo HR hat or HR people ops hat should dabble in. You really need to understand how to handle a situation like this. And I mentioned incidents and complaints. Those are specific terms from the legislation, and the requirement does apply to both a written or verbal complaint, of course. But where there's an incident that the employer becomes involved in, where there isn't a complaint attached, also that there's an obligation to investigate those as well. So erring on the side of caution and making sure that they're dealt with by the employer in a reasonable manner is really important. And it's not a standard of perfection that employers have to meet. It's acting reasonably and not sweeping things under the rug. We've seen lots of high profile cases where employers have gotten in trouble for just frankly not dealing with things. All right, moving on to the next slide. So talk tip number 2, the legislation specifically states that what's required is an investigation that is appropriate in the circumstances. That's a very key phrase. And what we do at Spring Law quite a bit actually with our clients is help them figure out what is an investigation that's appropriate in the circumstances. So they've had this issue that's arisen in their workplace, and sometimes it's a very serious one that needs swift action and a plan quickly. So and sometimes again it's that interpersonal conflict, and do we need to make a bigger deal out of this than it is? So back to that, the standard for the employer is to act reasonably. So figure out what is appropriate in the circumstances, and this is where, again, we advise on strategy, and we hear the facts, and we help our clients to figure out what plan is best to put in place. And that consulting with employment lawyers, we think, is a good idea. It's not a sales pitch. It's genuinely a good idea and a way to reduce costs and avoid headaches in the future. And there are lots of employment lawyers who are deal with this regularly and who have trained investigators as members of their firm and can help really get ahead of it at the front end, and that's important. The other thing I'll say is complaints by employees to the Ministry of Labor on the rise. It's very easy for an employee to make a complaint to the ministry about an employer that has not properly investigated a harassment complaint. And I had 2 come in the door last week. I'm involved in 2 investigations that were triggered by Ministry of Labor complaints. And the first thing that happens is an inspector goes to the workplace to find out what's going on basically and what was investigated. And I should back up. The first thing that happens when they get there is they ask to see typically they all operate slightly differently, but typically they ask to see the harassment policy. So you want to make sure that your harassment policies or your respect in the workplace policies, harassment, violence, and discrimination, whatever you call them, are OSHA compliant and posted in a conspicuous place, because that's what the legislation requires, and also just generally made available to employees. So on your company intranet, or this isn't gathering dust in a drawer for nobody to see. That's got to be front and center, and it's going to put you in a good position if you are visited by a Ministry of Labor inspector. You can say, here's our policy, this is how we operate here, this is what we did when we learned about this complaint or incident of harassment. So continuing on with this concept of appropriate in the circumstances. So when you have an issue, what's appropriate in the circumstances? Before we get, the initial steps are reviewing what is the incident, what's the complaint, and I've already referenced creating a plan. Really sit down, think it through, document all the steps that you take from the moment you hear of the incident or complaint. Probably a good idea at that point to consult counsel. And even if this is just a quick phone or relatively quick phone consultation to help create that plan, again, well worth it. And then documenting what you've done, who you've spoken with, not making premature findings at this point, or assumptions or comments, frankly, in emails internally about, this is Johnny up to this again. What are we going to do from here? Those kinds of things can really derail an investigation or cause problems at the end of it. So you have to remember that Johnny hasn't had a chance to respond to what's being said about him. And you have to slow down and figure out this plan before we make any assumptions. And the documenting all steps ties in with the last point about demonstrating procedural fairness throughout the process is really important. If this Ministry of Labor inspector ever ends up at your workplace, you'll be able to show how you handle things from the first moment. And just generally, if it is a matter that requires a full-blown investigation, then you will be able to show what you've done from the moment that you started. So if you find that what is required, what is appropriate in the circumstances, is something closer to a full-blown investigation. I'm going to talk about a few must-haves, but backing up a little bit, and if you find that this is more in the realm of a workplace interpersonal conflict and you're not sure that this really requires an investigation, that erring on the side of caution practice is still advisable. Have somebody review the matter who's arm's length and neutral and perceived to be neutral, go in and find out what happened and make a note of that. So that while not a full-blown investigation, is a process that the employer is going through to find out and make sure, frankly, that there's not some toxic employee or some conduct that needs to be dealt with immediately before it causes more problems. That's reviewed and documented, and then the employer or whoever's conducting this investigation, even though it's not this full-blown formal one per se, makes a note about how they handled it to make their steps defensible down the road if need be. So that's the more, those are, and it gets tough when it's gray and you're not really sure how deep you need to delve into the issue. But let's take, for example, the more serious misconduct, alleged serious misconduct, and you got to figure out who's going to do this investigation, and you got to select a trained investigator. Trained investigator is key. You don't want somebody dabbling in this who's not properly trained. It's not, frankly, fair to them, and it's going to lead to problems down the road because very often the unhappy party challenges decisions and wants to see what went on in an investigation, and the report, if privilege is not maintained or claimed or successfully asserted, it all becomes producible. So it's important to have somebody who's trained, whether they are internal to the company or external, handle the matter. And in selecting the investigator, you need to consider conflicts of interest and reporting lines and any potential biases when you choose that person, and really think about, can this person, while they may be capable of making an objective finding and an unbiased investigation, will others see it that way? And is this really the best person to handle this? So these are high level, this is a non-exhaustive list. There's lots of things to consider. We've picked things that can lead to, that are really the biggest pitfalls here, but it really does take a lot of careful thought before you dive in, an employer dives into the investigation. So continuing on with the process, if you've decided that you're needing to conduct a more fulsome investigation, and you decided that you are going to keep the matter internal rather than retaining an external investigator, we found that due to the cost of external investigations, many of our clients are saying, what is a more cost-effective solution? What else can we do here? So again, we will help them figure out a plan to handle it internally and advise them of the risk if we don't think it's a good idea. But if an employer is able to keep it internal, the first thing that that person conducting the investigation needs to do is check the mandate and really make sure they understand what they're being asked to decide. Is it a complaint of harassment or an incident of harassment? And am I looking at the policy to see if the policy was breached in some manner? Am I making recommendations? It's really important to go back to what that question is and to not deviate, because investigations can take on lives of their own. You have to really stay focused on what's at issue. Again, creating the plan and then following it. I'm sounding like a broken record here, but that plan is really key. Providing all the allegations to the respondent is important. It's a very important principle in Canadian law that a respondent not be ambushed by allegations and that they have a fair opportunity to respond to them, particularly if the misconduct is serious and enough to warrant a termination for cause. The employer is going to want to be sure that they gave them a fair opportunity to respond. There's lots of case law on that issue and the procedural fairness that's required around that.
And how do we say that in Latin, Marnie?
Who knows?
I have a guess. But... Great, go ahead.
Okay, no more skill testing questions, Hilary. Interview the parties and appropriate witnesses. The order of these interviews might vary, and again, that's part of creating the plan and figuring out logistics and predicting what information you might get in what order, and then lining up your schedule that way. So you've got to be flexible, and that's also part of what we can help with if a client or employer client has decided to keep the investigation internal. Gathering relevant documents and evidence early on is important too, because things get deleted and disappear. So we're talking about emails and text messages and any other physical documents that social media posts, etc., that might be kicking around that are frankly sometimes critical, very critical to the allegations. So gather that, think about what might be out there, and ask the parties and witnesses if they have anything relevant. So the continuing on with this non-exhaustive list of must-haves, this person handling investigation internally, make sure that you make a decision. You can't waffle. You have to make a decision either way. And investigations, the standard of proof is on a balance of probabilities. So it's really asking, is it more likely than not that this occurred? So again, it's not about getting it perfect. It's about, there's no necessarily a right answer in some cases. It's about doing a thorough and fair investigation, assessing credibility, and making that decision. So again, not putting someone in a position who dabbles in investigations is really important, because it's something that requires training. Preparing a written report, again, check your mandate and make sure that that's what you're being asked to do, but typically the decision or findings would be in writing, or that would be my recommendation anyway, even if it's in the form of an executive summary or brief report. Sometimes they may require a full-blown report detailing all of the evidence, but that's typically what is the last, or one of the later steps in the process. One of the last steps is advising the parties in writing of the outcome. And this in writing component is relatively new under OSHA, and it's very important. And in that written document or email, also to be included as any corrective action that has taken place or that will take place as a result of misconduct that's been found. And we also will advise employers on what should be contained in that written communication in order for it to be OSHA compliant, and in order to be considerate about what's going on in the workplace, and to be discreet about, sort of only disclosing what's necessary to be compliant under OSHA. Also consider appropriate workplace restoration, or any things that could help in the workplace afterwards, but be careful as an investigator not to provide this if it's not part of your mandate. I just flag it because I think an investigator who's interviewing parties and witnesses learns a lot about what's going on in the workplace, and I'm always coming at these issues from an angle of trying to promote positive employee relations. And leaving this information on the table seems like such a shame. So in going through an investigation, really think about, how could these issues have been avoided, or how can they be prevented in the future? And I make a note of that when I'm an investigator. And if I'm asked, then I'm able to make these suggestions, because I've done this deep dive into the workplace and I understand things that may never come to the employer's attention. So an investigator should keep that in mind, but again, don't offer it if it's not part of your mandate. But I think it's a real loss if it's not considered by an investigator, or internal or external along the way.
Yeah. Thanks, Marnie. It's a lot of must-haves.
Well, I could go on.
I know you could. Moving on from investigation must-haves, though, to our top legal issue number 3, auditing your employment contracts. So as employment lawyers, we love employment contracts. These really can head off a lot of potential issues down the line with the employment relationship if everything is set up properly in the employment contract at the outset. So the first thing employers may want to think about is, what kind of contract am I going to give this person that I'm hiring, either as an independent contractor or an employee, and make sure you have the right type of contract. So there are lots of employment contracts flying around out there if you just Google employment contract. But we would stress that it is important to get legal advice and to really understand what you're hiring for, what the obligations you as an employer are going to have to that person. So this is something that we offer in our subscription program, where we do provide sort of template contracts. We have these 3 types of contracts in our subscription program, and then we also offer to review these just to make sure that we understand that you're accomplishing what you set out to accomplish, and that everything is set up properly. So sometimes, you think you're hiring a contractor and that person's actually more appropriately an employee, and that's a sort of a nuanced thing to figure out and really important, because if you get it wrong, there can be big consequences. Another thing that we see often is employers who get their employees to sign their employment contracts once they've already started the job. And this is a problem because that's going to impact the enforceability of the contract. The contract requires what we call consideration to be valid. So consideration is something of value, an exchange of something of value. So before the employee starts, what they're given as consideration for signing the contract is the job. Once they have the job, we can't offer them that job as consideration because they already have it. And once that employment relationship has started, even if we don't have a written contract, the law would recognize an unwritten employment contract, and that's going to have different and usually greater entitlements than we would set out in the written employment contract. So this is a little bit tricky, but the key takeaway is never let someone start unless they've signed that contract. So delay that start date if you don't have that contract signed back yet.
Hilary, your discussion of consideration was far more interesting than my first year contracts law professor, so well done.
I'm sure it was much faster as well.
Yeah, much faster.
Yeah. Another thing that is good to have in a contract is the probationary period. So often we want to test out an employee, make sure they're a good fit. And in order to do that and be able to say goodbye after 3 months or right before 3 months is up, that needs to be set out in the contract. And so under the Employment Standards Act in Ontario, an employee can be terminated during the first 3 months of work without being provided any notice. So they can be terminated right away and stop being paid right away within those first 3 months, but that needs to be set out in the contract. If it is not, the employee may be entitled to notice, and notice is basically generally a continuation of their pay or a lump sum payment, and that's a concept that the law recognizes in order to bridge people between jobs. So if you've hired someone and they've only worked for a month, but the job was really rare and really valuable to them, there are cases where employers are required to pay that person like a year of notice, for example, because it's going to take them that long to find another job. And that's a situation that can be headed off by setting up an appropriate probationary period in the contract at the outset of the relationship. The other main thing, and I think this is probably what we would call the most important part of the contract and what a lot of our job is about, is the termination provision in the contract. So termination provisions are very technical, and there's case law about what's enforceable and what's not all the time. So this is always changing. We do keep our termination provisions up to date in our subscription program employment contracts, but if you're just using something that you had or you got from your brother-in-law or whatever, we really recommend that you get those termination provisions at the very least reviewed by a lawyer to make sure that they do contain those essential elements and legal requirements. And just in general, recently the courts have ruled that in order to limit termination entitlements, so this will generally be notice to the Employment Standards Act only, the clause has to be written in a very specific way. For example, it needs to contain the word only. If it says, upon termination, you will be entitled to the Employment Standards Act's minimums, but it doesn't say only, you could also have an employee end up being entitled to the Employment Standards Act minimums and the common law notice. So that can be the difference between 8 weeks and 2 years of pay. So ESA only, so that's Employment Standards Act minimum termination only, is what we often limit in an employment contract termination provision. So then when the employee is terminated, they know what they're getting and they're just going to get that amount they're entitled to under the Employment Standards Act. In positions where we're trying to attract a really desirable candidate, Often this is where the negotiation is going to go on around the Employment Standards Act termination provision, and we're going to see ESA plus, so plus some common law, and that's absolutely fine, but that gives the employer certainty upon termination. How much is it going to cost if we need to terminate this person? Maybe it's going to cost us, the Employment Standards Act, and then, an additional week per year of service, something like that. And that's just really helpful to have that certainty for employers. Templates. So I've sort of touched on this. There are a lot of technicalities in a contract. It is, they're not fun to read, except for us. The law does change quickly, and employers can really be on the hook for a lot if they don't set up those contracts properly. So we really do see every day problems that could have been avoided with proper termination provisions and proper contract drafting. So that generally saves the employer a lot of money down the road if they spend a little money at the beginning of the employment relationship getting that all set up properly. Takeaways, Marnie.
Okay, thank you. I see it's 11 o'clock, and I'm sure you're all wanting to rush off and check your employment contracts to see if they have probationary periods, and see if your ESA limiting clauses contain the word only. Yes. And Hilary also needs to go back to bed and nurse her cold and probably read some more case law like she likes to do. So I'll be really quick. 6 takeaways to apply. Is it 6? No, 5. But they apply to all of our 3 issues. Make sure employees understand conflict of interest, your moonlighting employees. What are they allowed to do, not allowed to do, and set it out in contracts and policies so it's very clear for everyone. Make sure you're set up for effective remote work if that's something that you're entertaining as a workplace, and watch our webinar on that. We did a whole webinar on remote work arrangements. Create that investigation plan to comply with OSHA requirements, and err on the side of seeking legal advice about the plan because it reduces costs and future headaches. We can help in that area. Get your contracts reviewed by a lawyer. It's well worth it. As Hilary said, we deal with things when they've gone wrong regularly, and often we read these, we think, oh shoot, a couple more words and we would have been okay. So get them reviewed regularly and make sure that they're up to date with the law. So that brings us to the end of our webinar. Thank you very much, everyone, for joining us. We'll be sending out a schedule of our webinars for 2020 sometime shortly, I'm sure. Anything else to sign off, Hilary?
So we didn't get any questions in the chat, but if you do have a question, feel free to email us after the webinar and we'll get back to you. Thanks, everybody, and have a happy holiday.
Happy holidays, everyone. Thanks for joining.